thanks to everybody for how you comported yourself during this trial. We did have some complications through the trial, and I appreciate how you rebounded from that. This court finds there's sufficient evidence that was presented that conditions created by 1145, which clearly was operating as a nightclub, were in fact a nuisance to those members of the public who came into contact with it regularly when it was open for business. Because a public nuisance, as noted by Mr. Dixon, may vary in its effects on individuals, the city doesn't have to wait for a calamitous effect to occur. It simply needs to significantly interfere with public safety. In this case, again, as noted by Mr. Dixon, a calamitous event did occur on May 12th of 2024 when both patrons and passersby were impacted greatly by a mass shooting. Sufficient evidence was presented to demonstrate routine interference with the public safety, the public peace, the public comfort, and the public convenience in this case based on numerous pervasive problems that were generated by and occurred in and around this lounge. These problems included the illegal sale of alcohol to minors and adults, the illegal permitting of patrons to use drugs, the outbreak of numerous fights, including gunfights and stabbings, a failure to properly screen guests, and the creation of dramatic traffic congestion, loud music, and littering. Further, I'll note that these nuisances occurred in the immediate area of a major hospital and specialty emergency medical provider. This is an especially dangerous location for traffic patterns to be significantly impacted. Finally, this court finds that no adequate remedy in law exists, and the evidence supports an injunction to abate this nuisance. The evidence is sufficient to convince this court that citation and suspension of licenses is not sufficient to abate this nuisance, based on the facts, as the business appears to disregard licensing and lease requirements. The court has no confidence that he would modify his business practices based on a municipal citation. Further, it's not clear that all the issues here are alcohol related. And I'll note, this court had to take Mr. DeFay into custody during this trial because he failed to appear to answer felony charges that he currently faces that are totally unrelated to this case. Even if the citation process could abate or somewhat abate some of the issues, the operator has a history of actively avoiding notice of citations and oscillating between truing up accounts, water and taxes, and having large arrearages to appear compliant for enough time to avoid legal consequence. Thus, this court has found that 1145 is in fact a public nuisance, and petitioners request that the court issue an order permanently enjoining and prohibiting respondents from holding events, serving patrons, or conducting and or allowing any other manner of operation on the property as set forth in the petition, and the amended petition is hereby granted. More specifically, as to respondent Bennett Street properties, the same is enjoined from permitting co-respondent from continuing the same or similar activity rebranded under a new name. More specifically, as to respondents DeFay, 1145, and Sovereign Entertainment, the same are enjoined from operating a nightclub as defined in the law at this location, regardless of rebranding with a new name or possession of a restaurant license. Will you prepare an order?
Yes, Your Honor.
Thank you.
Thank you so much.
Thank you, Your Honor.